Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Hello, and welcome to another episode of Life's Third Act, a podcast by Cordell and Cordell's estate planning department, talking about the things that are important to you related to estate planning. My name is John Sauter. I'm the senior estate planning attorney here in our St. Louis office. I'm going to be joined today by my good friend Melanie McDonald from Houston, Texas. She's a senior litigation attorney down there, and she is also a part of our estate planning department. We're going to be able to give you some unique perspectives on how things operate in different states as you're navigating some of these topics. Thanks for joining us today. As always, if you have any questions, please drop them in the comments. We'd love to answer them. We'd love to hear what you're thinking about. That's why we do this. So today, we want to cover something very practical. It's the question that comes up a lot that we deal with, which is what to do when someone passes away, right? You're in a situation where someone you care about, somebody you love, has left, and what do we do? I mean, you're left not with holding the bag, right? Not knowing what exactly you should do. And, the first thing I always tell people when they come into my office in this situation is slow down, right? We've got a lot to deal with over the next week or two as you're going to process this. We're going to do the funeral or whatever they've requested. Everybody's going to come together. The first thing we got to do is give ourselves a little grace as we move forward and realize that there's a lot to do, and we just pick one thing up at a time and do it. And that's how we've got this set up. What are the things that you need to deal with immediately? What are the questions you should be asking? What are the things you should be looking for? What are the things you can put on the back burner and deal with those as time goes on? But again, most importantly, stop, take the time to be with family, take the time to mourn and grieve. I see people make that mistake sometimes, and they regret it when they just get to, and I'm talking about this because I have this taskmaster mind, right? I go to that world where I just want to get things done, and you miss what's going on right in front of you. But in this instance, we're going to cover that. Our first thing we're going to talk about today is what to do right away, okay? In most circumstances, like I said at the beginning, things will be there when you come back from the funeral, but there are a couple things that you might want to think about right away. And so those immediate steps, the first one you want to ask, and this is really immediate, right? Has there been a pronouncement of death, right? Melanie, what do you want to do in that situation if you're not in the normal situation where you're in a hospital or you're in a nursing home where there's medical professionals there? If something were to happen at home, what would be the first step?
Well, in that instance, of course, if you're in a hospital, you're surrounded by the medical professionals to take care of what needs to happen in terms of that pronouncement. But when you're at home, it's kind of a scary situation, and your first instinct is going to be correct to call the authorities, right? So that someone can come out and assist you with that circumstance. And sometimes that may not necessarily be 911. It might be a non-emergency number. But if you don't know that number, then 911 will do. But you want to reach out to someone and make sure you let them know that someone has passed away so that they can send the appropriate officials. They're going to send over a medical examiner or one of the deputy medical examiners to come out and actually do that pronouncement of death. So that's the first step, that if someone is to pass away at home or, in a circumstance where you're not in a medical setting, that's going to be the first thing that you want to do.
Okay. So that's first, and that's very immediate. What's next? I think we're thinking about looking at what's around you, probably, right? Is there anything they need to do with the house or with valuables?
Well, I think that in that idea of you secure the decedent, right? You make sure that that is done, but the next thing to do after that is to secure the premises, right? You want to make sure you have a situation where you're not leaving the house unattended. You're not leaving the vehicle because people are going to see. They're going to see the ambulance pull up, or they're going to see the funeral home where they bring the hearse and to pick up the body. But they're going to see that occur. That can give an alert to a lot of unscrupulous people of what's going on in that scenario. So what the next step would be is to secure the premises, secure whatever assets are there visible, put the car in the garage and do those types of things to make sure that the assets are secure.
All right. And then what about, how do we know what somebody's wishes were? And this is all going to move really fast, right? The body's been taken away. You're securing the property. Next steps is what, a funeral home?
Well, that is a part of when they come to secure the body, because one of the questions that the medical examiner is going to ask is, what is the funeral home? Have you contacted the funeral home? Because the body must go from the hospital setting, like once they pick up the body, it's going to have to go from that setting to the funeral home, right? So if you haven't contacted one, that would be the next thing to do. Now, that's not something that needs to happen right away while you're standing there in that moment. But in the next day or the next 2 days after that person has passed away, that's when you need to make sure that you're out, you're speaking to the funeral home. The funeral homes have very good, and most of them have very good counselors there, people who are trained in that field to be able to talk to you about what the process is, how we pick up the body from the hospital, get it to the funeral home, and what that process is in terms of preparing for that memorial service.
Okay, and this is something that's come up in my practice fairly regularly, and it can be something that is kind of contentious because we're talking about the funeral home. Let's say we're from a family with multiple children. We've got that the usual suspects of the oldest child, the middle child, and the baby child. I always use that example of 3 kids because it's just I can almost predict what's going to happen. Who has the authority to act, right? If the body goes to the funeral home, decisions are going to need to be made.
That's right. And I think that let's throw a monkey wrench in it. Not only do you have the oldest child, middle child, and the youngest child, but what about a blended family where there is a prior spouse and the children from that family and your current spouse? So when you have a situation where you are looking to who that person is that's in charge, one of the things that I've done, in my practice is to make sure that that person is identified. So when we start talking about what are we looking for? So of course, the funeral home is going to look to the next of kin, right? They're going to say, who is the next of kin? In Texas, we have documents to designate who that person is. If you are a person who has not put together an estate plan, you're going to be a person that has to basically appeal to that funeral home who you are and why you have that authority. But that does not mean that someone else is not going to be able to say, well, that may be his oldest child from his previous marriage, but I am the current wife. And so I believe that I have a say-so. So now you have the balancing between the two. Who is that funeral home going to look to as the next of kin? My prediction is going to be that the wife wins, but it's not going to be without some drama and without some backlash from the other family.
Yeah, and we actually had a scenario come up recently that's exactly what you're talking about, but I'll throw in another wrench. The wife and the husband were in the middle of a divorce. And so in Missouri, and what we're talking about here when we're talking about next of kin is it's not just, naturally, who do you think should be in charge in this situation? There are actually statutes written about that order of who's in charge, right? And in Missouri, similar to Texas, spouse is first. But there is a caveat in there. If there had been a filing for divorce and that divorce was active, then that person's disqualified. And then it went to the next. So let's say that the person, and this happens, you don't always want your spouse to make certain decisions. You don't always want your eldest child to make decisions. What if I want to name somebody other than what the next of kin statute says? Is there a way to do that?
Now, in Texas, we're a little bit different. So, of course, there is always a way to put things out of order in terms of what the statute says. Okay.
Yeah.
And now in Texas, of course, you have the battle between who it's going to be. Is it going to be the oldest child? Is it going to be that spouse? Even if you're in the middle of divorce in Texas, guess who wins? The spouse.
Okay.
Even in the middle of a divorce, that spouse is going to win because that divorce has not been made final, and the divorce will die when that individual dies. So
Okay.
that's when it becomes very important to consider what type of contractual obligations are you giving people when you're putting together your estate plan? Because if you don't want that to be your spouse, under the Health and Safety Code here in Texas, we have a specific document that basically nominates an individual to be able to make those arrangements, and they're going to outrank everybody. So
Okay.
notwithstanding what the statute may say, the next of kin, who that may be, you can literally put together a contract that person has to accept responsibility for and say, that's the person that I want, that I believe is in the best position. That document, if I were entering into a divorce, that would be the thing that I would do if I didn't want my spouse to be making that decision and cremating me perhaps when I wanted to have a regular funeral. So that's kind of where the way that we handled that dispute here in Texas.
Yeah, and here we use the healthcare power of attorney, so it's wrapped into another document, and this is just the kind of stuff that is just so not intuitive, right? About
Right.
whether or not it's going to be, people think probably intuitively next to kin, but there's ways to do it. Is it in this document? Is it in this document? It's why you need a professional to help you when you're trying to put this stuff together, because if as a person that operates in Missouri and Illinois, if I'm in Texas with my family, I'm going to make presumptions that aren't right, and we've learned that a lot as we've been working through this process. We might just call this episode "Throw a Wrench in It," because I'm going to throw another wrench in here.
Okay.
Something that comes up early is money, okay?
Mhm.
And who pays for all of this, right? Now we've got an ambulance that came to the house, right? We've got vehicles. We might have had to change locks. We might have had to secure things. I don't know what happened there. We're going to end up at a funeral home. Somebody's going to have to pay for that. We've got no kind of formal proceeding that's been started at this point. Who pays for these things?
So in a lot of situations, you're going to have multiple sources for where this money is supposed to come from. So first, let's talk about the funeral. In that situation, the question to ask there is there insurance or is there not,
Okay.
right? Because if there is insurance to cover the funeral, that's going to take care of that part of it, right? If that person is the beneficiary to an insurance plan, they have the ability to sign an assignment over to the to the funeral home. They're going to contact the insurance company. They're going to take care of all of the paperwork all the way through to the death certificate, right? But when there is when there's no insurance policy and no one's been designated as the person responsible for that, then ultimately the expenses related to the last illness and the death becomes the burden of the estate itself.
Okay.
So now we're moving away from like what to do in the immediate sense, and we're thinking a little bit further ahead in terms of when this particular estate is probated, right? Because that is the space where the person who's paying for all these things, that's the place where they actually have reimbursement. So we can throw another wrench in there, and it's like, well, what if that situation is one where the person doesn't have that money, or that money is in the bank and it's the decedent's money in the bank? How do they get it at that point? And so you still have a situation where the individual who is making the decisions may have to make an initial outlay, but they do have a vehicle to be reimbursed if the funds are there to reimburse them.
Yeah, but at that point, it wouldn't be clear, right? Because so you say probate, and by probate, you mean court, right? If this
Yes,
estate is going to end up in court, at that point, whoever has paid the bills will have an opportunity to what we would make a claim against the estate to be reimbursed for that. But listening to what you're saying, I think the most important thing when everything's so unknown but moving fast is just keep those receipts, right? Track
Absolutely.
everything. And maybe even if you're not the person that's named to act, but you're putting out money to help things, right? Because you're a good person. And this is one of the saddest things I see when I'm helping people with administering estate is how often good people get hurt because they're trying to do good things and they're not protecting themselves, right? Because they have a tendency to not do that. And I'll pay for that. I'll pay for that. And in the end, when it comes back around, if they didn't track it properly, they might not get taken care of.
That's right.
Something that also comes up that's another responsibility when somebody passes away, an obituary, right? How do we get notice to everybody that this has happened? How does that come about? Who writes the obituary?
Well, I believe that that's another situation where it becomes a collective effort, and it also comes back to who that person is that is being contacted by the funeral home. Sometimes the funeral home can help you actually write the obituary. They're going to ask you, what is it that you want the obituary to say, and what were the accomplishments of this individual? What is the information that you want contained in that notice? One of the things that I often do when I'm considering this, like when I'm talking to a family immediately after, because they call the lawyer and they say, well, my mom, my dad, my aunt, they just died last week.
Yeah.
And it's like, well, it's too soon to be in my office if they just died last week.
Right.
Let's take a few steps back and work through some other things. But I always warn them to be very careful about the information that they put even in the obituary, because in an age where there is rampant identity theft, you want to be careful about whether or not that public notice is a choice that you make. Surely, if it's a public official or someone who has a notoriety in your community, surely you want to make sure that that is a notice. But for the everyday person, it's something that you have to think about, and whether or not you are making their estate or their identity vulnerable to someone who has nefarious intent.
Huh. I hadn't thought about that. What kind of information could they get out of an obituary? That would
All
be
you have to know is that a person died, and then you let someone's digital fingers do the walking. Because if I have your name, I can log on to sources like public data and, all types of things and find out things about you, track down things about who you are. Identity theft is something that is scary. And I think that a lot of times that it happens to folks, especially when they pass away, because who's going to complain about it? The dead person is gone.
Right. No, that's a great point. I was going to make a point about obituaries because and it wasn't that. That's a great one. I will remember that. But I have to read a lot of obituaries, right? Because they come in the office. That's where I get a lot of information. Sometimes if you make a call and you're coming in, I'm going to start looking things up, much like the scammers are doing, but that's not my intent, right? And I'll find an obituary, and I really appreciate a well-written obituary. So, the ones that aren't formulaic, the ones that tell a story, it's a lost art to me, and I really wish we put a little bit more effort into doing that. And maybe it's just me, but anybody out there?
But you make a good point, and I'm going to tell you why. Another reason why sometimes it is good to even consider the obituary, because if this is a person who has not called us to do their estate planning, they haven't contacted us to put a plan in place, that obituary can potentially become evidence in a situation where you have not properly planned, and we need to determine who your heirs are. So one of the first things that I look for as a litigator, and I'm saying, okay, you come into my office, there is no will, there is no trust, there is no plan, but we still have to go through this process because there are assets out there. Well, the first place that I'm going to pull the obituary so that I can determine who are the family members.
Mm-hmm. Did you see that, folks? Melanie took off her estate planning hat and put on her litigating one and looked at it from that perspective. And it's one of the benefits of being here at Cordell is we do have all of this perspective on handling these situations. And while you may be running through these things, you sometimes need to stop and take a breath and say, what are the consequences of all the things that I'm doing if I'm acting without thinking? Okay, so we're past those first few days, right? We've gotten through the blur that happens when somebody passes. What's next? We talked about who can act in relation to the body, which in Missouri we love the Latin. We call it the right of sepulture, right? Who can,
I like that.
Yeah, I do too. But then going forward, right? Not just the body, the rest of the property. How do we know who can act? We talked about the estate and the court and reimbursing, but who's in charge?
So that becomes a question again on whether or not we have a plan or whether or not we don't. So first looking at if we have a plan, because of course that makes it easy. And your plan is going to consist of, multiple documents. You're either going to have a trust or you'll have a trust and a will and other documents that talk about who has the ability to make decisions in that situation. When you have that circumstance, it's very clear. Someone's been designated, you filled out all the forms, and you should be able to follow the forms, right?
Yeah.
But when you don't have someone designated, I think that that's where the real question comes in. Because at that point, the court is going to acknowledge whoever it is that steps forward that is a suitable person per the court's determination. So, for example, if you are trying to coordinate everything and you're taking care of the funeral and you're just showing the initiative and no one's giving you any flack for it and you approach the court about that estate, then that responsible party or that party can be determined by the court to be the individual that they will appoint to manage all of the affairs. If you have a plan, it just makes it so much easier because you've already designated who your trustee is or who your executor is. And that's going to be the person that actually moves you into that next phase.
So here's a question. If somebody does have a plan, they create a will, they create a trust, is that filed somewhere?
No. And so this is going to be one of the things that I do in practice that becomes really critical, that I have a checklist that I use that I'm like, you may have your will inside of a safe deposit box or in your bottom desk drawer or in a file cabinet somewhere, and your family is going to spend months. And here in Texas, they have 4 years to find it, right?
Wow.
They can look for it for 4 years. And if they haven't found it in 4 years, they can go ahead and move the court to take care of the issue. But they have that long to figure out, was there a will? So that gives you time to check the safe deposit box, check the top desk drawer. I've literally had someone take their estate planning documents and tape it under their bed in an envelope, and it's stuck under the bed. I'm like, who would think to look there? It's
Who
like,
found that? The cat?
They didn't find it until they were moving everything out of the house.
Oh my God.
And it's like you turn over the box spring and there's this envelope taped to the bottom of the box spring. And I was like, why would you do that? But that's what they did.
Why
But,
would you not tell somebody you did that? Is maybe
exactly. Leave a map. You have to leave a treasure map. And that's the way that I think of it is if you leave a treasure map, someone's going to be able to find that map. So that means that you have written a letter to someone and put it in an obvious space. Put it someplace that is very obvious, even if your will is in a safe deposit box or your will or your trust is in a safe deposit box or in a fireproof safe in your house. But if I was just there and I'm looking, of course, it's hard for me because I'm going to know all the places to look.
Right. Under the mattress.
Right. I'm looking in between the mattress. I'm checking the cookie jar in the kitchen. I'm checking everywhere because these are the crazy places that we found documents just in practice. But if you are the person who is partially grieving still, where are you going to think to look? And so it literally becomes a treasure hunt without a map. You're looking everywhere to see whether or not there is a document that can lead you to something, looking for paperwork from an attorney's office. Oftentimes, if you can find a business card or an invoice, checking the email if you have access to see whether or not there's been communication with an attorney of some type. So you have to look for the breadcrumbs. So this to me becomes the hardest part because you literally are on a treasure hunt with no map.
Yeah, I had a client the other day that we were trying to figure this out. What we ended up doing was pulling the deed to the house, right? Looking at the notary on the deed. And then we got lucky because that notary was the attorney, right? And then you're able to look it up and then call them and see if you can get it. But it's funny, people hide things in the weirdest place. It just reminded me of my mother because as I was growing up, she would take things away from us, right? You know, like a slingshot or something. And after a while, I would be like, Mom, stop. Where are you going to put this, right? Because she would hide things and then we would never see them again. Even, you'll get this back in a week and it's like, you could wait the week, but she has no idea where it's at. It's somewhere in that closet of hers. Okay, so 4 years, that's an interesting thing to me. Again, counterintuitive. I've had people come to my office and and when somebody passed away, there was nothing that was really pressing at that time. Maybe everything was titled to go directly to people. They never used the will. And they'll show up in my office and they've got this will and they'll say, okay, we need to use this now. Now, you said 4 years. In Missouri, it's only 1 year. Okay.
Wow.
If that will isn't filed with the probate court within 1 year, it's not valid. It's void. Okay.
Wow. Okay.
Right. And so it's not even informative after that point, which the reasoning behind this is they want to keep things moving, right? If the will's not found or not used, let's move on. In Illinois, if it's not filed within 30 days of the person passing, any other interested party can step forth and begin the process.
Wow.
And so those are things that you probably would not think about. And so the way I explain the will to people is it's a document that doesn't come to life until a court breathes the life into it, right? You sign
Absolutely.
it. So many other contracts we sign, they're immediately effective. A will's not effective until a judge signs off on it, right? So just a thing to remember, even if you're not going to use the will, that might be something you want to file. And so we talked about how we determine who can act. What happens with the property? How do we know who gets it?
Well, of course, in a circumstance where there is a will, you're going to follow the will.
Mm-hmm.
In Texas, where there is no will, our legislator said that's no problem. We're going to write one for you.
Okay.
And so we simply follow the laws of intestacy, which is going to be what they have deemed the logical path of property through your lineal heritage. Like you're going to look at, who are the parents, who are the children, who are the grandchildren. It's going to follow that entire consanguinity chart in terms of who is the next of kin, right?
Mm-hmm.
And we go down until we find someone who is entitled to take. In that instance, though, and when we're talking about looking at the obituary in terms of who was named in the obituary as the children, because sometimes you've named people in the obituary, but there are others.
Okay.
So when you haven't written that will, what we do here in Texas is that we have a particular attorney assigned as an investigator who had their literal job is to go out and paint for the court the picture of what that family lineage looked like. And it really is a matter of them doing the investigation, looking for that obituary, talking to the neighbors, talking to the other family members to figure out, is there anyone else? So that when the court declares these are the heirs of that estate, that becomes the takers for any of the property that is there. So when you don't have a plan in place, Texas will write one for you. It just may not be who you intended, right? So if you have a specific wish, you got two options. You either got to go and put it in a trust so that something's transferred to them without the necessity of probate, or you put it in a will where you have the probate process to go in and have that property transferred to your intended beneficiary.
So if you do have a will, do they not do that search?
No, they do not do that search with a will. The only time that they're going to do that search with a will is if, for example, there is certain property that was not included. That rarely happens because it is standard in our state to have a residuary clause. That residuary clause is going to catch everything else. So anything that would not have made it into the will and been, bequeathed to someone, that is going to fall into that residuary. And if you have a will without a residuary clause in Texas, I can guarantee a lawyer didn't write it.
That's 101 for will writing in Texas.
Yeah, that is 101.
Yeah. We do the same here, but that investigative process is something we don't have. And I was curious about what triggered it. Okay, so yeah, if there's no direction, they're going to. In Missouri, we're way more hands off. You just publish in a local legal newspaper, and we assume that whoever needed to know knew from that. And if they don't show up, they're out. Okay.
Wow.
And so a lot comes from that, good and bad. And so if you're showing up at the court, you're showing up wherever, and you've got to prove that this person has passed away. How do you prove that?
Well, of course, that's going to be with your death certificate. And that's where you're going to work very closely with your funeral home, right? Because no one's going to expect you to know all the things to complete
Right.
within the BVS form that we file with the state in order to have a death certificate issue. But the funeral home, that is a part of the services that they offer. They're skilled in doing it, and you want them to do it. And what they're going to do in that process is they're going to gather the information that you need to submit that document to Vital Statistics. Sometimes that information, so some of the information comes from the medical examiner or whoever it is that did the designation that this individual, has passed away, and they've done, the determination of how that person died, because all of that information is included on that form. And they're going to have a person who is the information giver. That person's name is listed on that death certificate as well. So the funeral home typically handles that. They're going to work very closely with whoever it is that stepped up and takes charge. Because keep in mind that even if you have a will, at the point of your death, your executor, they may be in charge when the court puts them in charge, but over the funeral and all of that, if you have not designated someone, you still don't have that. The person as the executor does not have the ability to act in that sense. They have not legally been put into any position of power.
Oh, interesting.
So,
Just being named in the will doesn't, you got to wait for a court to appoint you before you can have the authority.
that's correct.
Okay.
The only way that you have authority without going to court is if you have a situation where you have a trust, you have duties that are laid out in that trust, and a part of that is to handle whatever your last wishes are regarding your remains. But as far as, in that period, what I call, it's literally a period when your power of attorney dies and your will has not yet taken effect. So what do? And that's where our health and safety code provides those two documents where you've designated particular agents to handle that situation.
That's good, because that is quite the gap. And I think this is one of the biggest misconceptions I see people dealing with is I'll get that phone call and it's a new potential client, and they'll say to me, "Yes, I'm the executor of my mother's estate." And I say, "Oh, really? How do you know? How do you know that?" Right? "Well, I'm named in her will." Okay. And like I said before, well, that's not an effective document until the judge said so. So just kind of and a trust is a trust different in that scenario? If you're named as the trustee in the trust, do you have to wait for court?
Absolutely not. I mean, that's a completely different situation, because a trust to me is more of a living document than the will is, right? The will they have to have life breathed into it. I think that was the example that you gave.
Yeah.
It has to be, it has to be activated, where a trust does not. And depending on your circumstance, one may be preferred over the other. But in an instance where you have a trustee who can act immediately, they don't have to wait for that process of probate or anything like that, or to get the court's blessing in order for someone to act.
Yeah, and I counsel people on this pretty regularly, because I'm always thinking about that gap when I'm doing estate planning. Sometimes people will put a house in a trust, but they don't put the checking account in there, right? And so now you've got the checking account. I gave that to my granddaughter because she's always been good to me, and she showed up, and I will give you a pro tip here: show up at the end, right? They're watching, all right? They're taking care of people, and she gives the money to the granddaughter, but the house now is in the trust, and there's nothing to pay the bills, right? So these are things you're thinking about when you're doing estate planning, and so. Identifying assets is kind of what we're talking about right now. What are the things that they need to be gathering in relation to the person's property?
And I don't want to seem glib. It's like everything, every statement, every piece of paper, every piece of everything that has anything to do with their property. Now, of course, we can pull some documents from the county records. I can pull a deed and see what the legal description and all of that is in terms of the real property and that type of thing. But every piece of property that you have, whether it is a bank account, a retirement account, IRA or 401k, a brokerage account, anything like that, any of those statements. One of the things that in one of my consults earlier today, that we were discussing, what other documents other than your estate plan should you have available for that person who is going to be taking care of things? And I just gave them a whole list of everything that I recommend, which is you're going to have at least one statement. I said, and you can change it out every month or every couple of months or whatever you need to do, but make sure there's a statement for every credit card, a statement for every bank account that is somewhere with your estate planning binder.
Yeah.
Make sure that there is a tax return from at least the most recent year of you filing. And if you have to change that out every year on tax date, maybe that's what you do, is that every year on tax date, you're updating whatever those documents are that you're putting in there, so that we have at least a bank statement that was within the last 12 months. We have brokerage account statements. We have different things so that we know where these assets are. If there's a vehicle, of course, the vehicle parked in the front yard, we know where that is. But if you have someone else driving a vehicle that belongs to you, and they're not at your house, they might be your son, your daughter, whomever, and they may be somewhere else. They may be adults and they're living elsewhere, but the car is in your name and you haven't moved that to them, then we want to make sure that we know what that asset is, where the titles, even if it's not a clear title, where is the pink title that it's still an encumbered piece of property. That will also tell us what the debt is associated with that vehicle. What can I do with that? This is all information that I'm going to need if I'm going to go through that probate process with or without a will. If I've titled those things to my trust, which is very difficult, with vehicles, especially if you're changing vehicles, if I've titled those things to my trust, then I'm going to have a clear lineation of where that asset should go. Right. But if I'm having to go through the court process, I want to make sure that I've had an opportunity to identify all of those assets.
Yeah. And you brought up something that I want to touch on for a moment here, and it's titling. Right? You talked about titling things to your trust. What if somebody else's name on the title, right? You talked about the kid, and we've given the car is in the kid's possession. It could be in your name, but what if both of their names is on there? What happens then?
When you say both of their names, you mean the decedent and the child?
Yeah.
Well, that's a kind of a different situation, because if you have a right of survivorship on any type of title document, you're not going to have to worry about going through the court process in terms of who takes that asset. Sometimes that is the case when you have a house, and that house is deeded to two spouses, and there is a right of survivorship because when that house was purchased, it was a purchase, after you guys were married and you both had to sign on it. And there really is no need for a process in order to transfer the title to that, or to transfer the deed for the house, right? Because there's going to be that right of survivorship. In an instance where you have a child and a parent, it may not necessarily be joint tenancy with the right of survivorship, but there might be a different ownership scheme. But because both names are on that document, typically on the title of the vehicle, it'll say it on there. And on the back of a Texas title, you have the ability to sign that and say, this is who I want to have this car at my passing. And I always encourage anyone that comes in to do an estate plan with me, that regardless, if your child's name is on the front, you're also going to sign on the back that says that you want the child to keep that vehicle should something happen to you.
Oh, okay. Belts and suspenders. And so this is where usually in the initial consult, I'm starting to see my potential clients' face glaze over as they're thinking about, we talked about probate, we talked about a trust, now we're talking about titling. There's a lot of different avenues that we can go for transferring property, right?
Absolutely.
And so it's the title that really dictates everything, right? If it's the person's name on the title and it's their name alone, and there's no, like you said, designation on the back or any kind of other joint owner, that's something we're going to have to put to the side because we don't have any direction on what's going to happen. And you can almost think about this as buckets, right? You're going to put all of the stuff that's joint titled just in that individual's name in one bucket. Everything that has a joint titling, and that can be confusing because is everything that's jointly titled automatically go to the other person?
Not necessarily. Sometimes you have an undivided 1/2 interest in that asset. And that's why it becomes very, very important to understand what the particular ownership scheme is for that particular asset. Because if you purchase, say you weren't married when you purchased the house, and it's going to have your name and the other party's name on it, but eventually y'all got married. Well, there's no right of survivorship in that instance, right?
Oh, really?
Because
Even though they're married?
Even if you got married after you purchased the house, no, there is
Okay.
no right to survivorship in that instance. You would have to literally make sure that that was done either by trust or in your will, because what that is considered to be is the separate property of interest of each party that signed that title.
Okay.
So, or signed that deed. So when you look at that warranty deed, it's going to be that person as a single party and the other person as a single party. They're not married. Only marriage is going to give you that automatic right of survivorship.
Okay. So I'm going to make 3 piles here. One that's anything that's in that person's name alone, one that's in jointly owned, and one that is going to go somewhere else, like an entity or a trust. And I'm going to hold on to that till I talk to the attorney, because I don't know if I can figure all this stuff out, right?
Right. And chances are they can't figure it out, and that's why we want them to call us.
Right. Okay, so another thing that comes up, and this is something that comes up pretty quickly, the mail, right? You were talking about information, right? Statements and things that you want to, and I think that's really smart. The annually, when you're doing your taxes, you're already in there looking at all this stuff, printing it off every year. That's a great tip. But what about the mail? Can I open the mail?
In Texas, you can't open the individual mail until after that person who is supposed to be designated as the executor is in place. But does it happen? Yes. And who is going to complain about it? Because the person you're offending is dead. So,
well, doesn't the USPS have a whole separate set of investigators?
They sure do. And when they show up, who are they going to talk to? It's one of those things where I literally say we create certain parameters to enforce things that are absolutely unenforceable.
Okay.
Because literally, unless the postal inspector is sitting there when you open it, how are they going to prove it? And who's offended by it, right? It's one thing if there is a fraud that's taken place, like we talked about nefarious actors. And unfortunately, sometimes that's something that we see in probate situations where there is a person who opens the mail and there's a credit card in there, and they take the credit card and they do things, after this person is deceased. And that's very unfortunate. But does it happen? Yes. Is that illegal? Absolutely. Is that something that's easier to trace? Yes, because if there are transactions after the party has passed away, it becomes very clear that it wasn't them that was down at Walmart shopping, right? So that one's clear.
that option's foreclosed.
Right. That option is foreclosed. But in a situation where literally the person that's opening the document is doing so for the preservation of the estate, an argument can be made that, yes, I had to open the light bill so that I can make sure that it was covered, because I want the electricity to stay on for the protection of the asset. I don't think the postal inspector is going to show up and be like, oh my God, you paid the light bill, you paid the water bill, and you did these things, and now shame on you. So it becomes one of those things that who's going to complain about the bills actually being paid and things being taken care of, because the decedent isn't there, and anyone that is a beneficiary to that estate, whether it be by trust, will, or even if you don't have a will and the state is writing it for you, they're going to appreciate the fact that someone stepped up to preserve the assets in that estate.
So it sounds like I've got to use my common sense sometimes, right?
Yeah.
Because this gap is confusing, right? Because the only person that had the authority to do everything on behalf of the decedent was the decedent. They could have named in a document who can act on their behalf. It sounds like the most helpful one is really who can deal with the remains at that point. But then the property, I mean, you could really be in limbo here on some of these decisions, whether or not I should open this or do this or take control of that. So let me take it one step further. Could I don't want to have to go over to grandma's house and open up the mailbox every day, right? Or I don't want it to let it get built up because, like you were talking about earlier, we don't want these signs that show that a house is vacant. Right? Because it's dangerous. I don't know if it's as big now as it was 5-10 years ago, but people were looking for that stuff and going and stealing copper out of basements and
absolutely.
And so we want to avoid that. Can I go to the post office and have them redirect the mail?
I knew you were going to say it, and no, you cannot.
One step too far, huh?
One step too far. Until you have that document signed by a judge appointing you as the executor of that estate, you cannot do that. If that authority is given to you in a trust, that is different, right? Because that trust is going to be a fiduciary who has certain responsibilities, but you cannot just say, oh, okay, well, I don't feel like driving, so I'm going to change, because literally on the change of address form, you'll notice that there is a place for an authorized individual
Right.
to sign it.
Uh-huh.
And I don't know how you can sign it as an authorized individual if you haven't been appointed in that capacity by the court or designated as that person through some other means. And keep in mind, your statutory durable power of attorney died with the decedent.
Yeah, that's a big misconception, right? I've got power of attorney. I hear that all the time and go,
Yeah.
you don't anymore, right?
Yeah.
You did, but that's something that their authority ended when they couldn't hand it off anymore, right?
Right. I think that one of the things to consider there is that when we're talking about estate planning, and we'll probably get to this in another episode or in another podcast, but the idea of what do I do in the incapacity? Because if that is something that was done during an incapacity leading up to the last illness, then that would have been perfectly fine for you to go ahead and fill out the document and
Oh.
say, I'm going to change the address while that person is still alive, because they can authorize that, right?
Yeah.
I'm sick. I can't get there. I have physical disability. I can't get to my mailbox. I want everything over sent to my daughter's house. Or while you have power of attorney or guardianship or whatever the status is that gives you the authority to act over that individual, that's when you change the address on the mailbox.
That's a good tip. Another good tip. All right, so we talked about the light bill, right? What about credit cards? What about I'm getting the mail, I'm opening it up because Melanie said it was all right. And I'm going through all this stuff. That's what I'm telling the postal inspector. You have to call Melanie. She said it was okay.
Oh, Melanie, she said it was okay.
I'm going through all this stuff. Should I pay the credit card?
Well, I would not pay the credit card bills. I would not pay anything other than what was necessary to preserve the assets of the estate. And the reason is because every creditor, at the point that a person dies, that creditor has to make a decision on how they're going to pursue their claim against that dead person, right? So you have you have a situation where they actually have to lay claim and go before the court and say, this is what my claim is, and this claim has to be verified, and a whole bunch of other steps to go through to make sure that it's a legitimate claim. But one of the things that happens when you're talking about a credit card, that's an unsecured creditor. A part of the risk that they took when they gave that credit to a person that is unsecured was that they may die and not pay you. So that's a part of their risk. So that is not something that I would say, oh, go and as soon as the person passes away, go and take the money and take all the money in the account and pay off all the credit cards. I would not do that.
Okay. And so you said it's an unsecured. What's the difference between unsecured and secured? I don't.
Well, say, for example, your house would be a secured debt, right? Because the debt on your house is secured by that particular piece of collateral.
Oh, collateral.
So if you have so if you have a secured credit card, you've put down money, and that money is going to be, say, I don't know, $1,000. Well, that's the extent of your credit limit. And if you should pass away, that secured creditor is going to have, to the extent that they have that deposit, to collect against whatever it is that they're owed.
Okay. Yeah. I think I want only secured debt from people that borrow money from me, right?
Right? I agree. Otherwise, it's a gift.
Okay. So something that people don't think about when they're thinking about debts, right? Because I find people are very eager to want to pay things because they're thinking about their own life, right? And like, oh, you got to pay them. We don't want the credit card company coming after us. Well, first off, there's nobody to come after, right? Like the USPS thing, the decedent is gone, right? And they're not going to come. They're not going to come out. There's nothing they could do. Okay. The second is there can actually be liability if you pay a debt that was not valid, right? And with the amount of mail and email and stuff I get today claiming to be receipts for things I didn't buy and debts, your best bet is to wait, right? Anything to preserve the estate, go ahead and get it done. You got to keep the electric, the water, the gas, all that stuff flowing. But anything above and beyond that, let's wait until we've met with the attorney. And
Absolutely.
that's actually where I'm going to stop for today, because we're about to talk about meeting with an attorney. That's what we'll cover in the next episode. Thanks for joining us today. If we covered something you had a further question about, or if there was something you thought we'd talk about that we didn't, please drop it in the comments. Melanie and I would love to respond to you and give you an answer to that thing you're looking for where you came here searching. Thanks for joining us today. Please join us next week for the second installment of What to Do When Somebody Passes Away. What are the things that need to be taken care of? We appreciate you joining us.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.